It's not something you ever want to think about, but unfortunately it happens. Children, like adults, suffer injuries and perhaps need a personal injury lawyer. Grand Rapids personal injury lawyer Tom Sinas, our sponsor, has been working in this community for more than a decade, and he's here to speak with us today about children and personal injury cases and what you need to know. Tom, welcome back to 8West.
Thank you again for having me.
So yes, obviously a topic that no one really, wants to see themselves involved in, but let's start with the basics. Obviously, minors can't file legal action. So how do courts handle a situation when a minor needs to pursue a personal injury claim?
So we start from the premise of your question. You're correct. A child cannot go down to the courthouse like you or I could and file a lawsuit, regardless of what kind of lawsuit it is. So how do we do this? Well, we have ways of giving adults legal authority to file a lawsuit or bring a claim on behalf of a child. The most common way this is done in, say, a personal injury case is most often the parent, doesn't have to be, goes to court at the time the lawsuit is filed and asks to be appointed what is called the next friend of the child. That's the term we commonly use in Michigan, next friend of the child. And the court will commonly appoint that person as long as they're qualified to serve. And then that adult, acting as next friend for the child, will prosecute the case in court on behalf of the child. Now, there are other designations you can give to an adult that allow them to prosecute a case as well. For example, an adult can be what's called a conservator for a child. Conservator, think of a person who manages someone's money. It's not common to see that because most children don't need a conservator before they're injured. So most of the time you have adults seeking this next friend appointment. But all of that is to say you have to get an official legal designation from the court to be an adult who prosecutes a case on behalf of a child.
So are the court rules and statute of limitations the same when dealing with minors in these cases?
They're different. And it goes back to the initial premise of our conversation. If a child can't prosecute their own case, then they should be given more time, of course, because they're a child. So we have this concept, you mentioned the statute of limitations, that's the deadline for when a case needs to be filed. With children, the law uses a procedure called tolling. Think of it as like a pause, pausing the statute of limitations, meaning that it's not gonna run while the child is a child. So now there are various exceptions and sometimes quirky rules here, but generally speaking, think that a child who's injured as a child really has until about their 19th birthday, sometimes more, has about till their 19th birthday to file a claim on their own behalf. So that statute of limitations, generally for personal injury cases, this is important to know, is generally 3 years. So if someone is hurt today as an adult, they've got until 3 years from today to file a lawsuit. If they don't, they are time barred, meaning they cannot. But the child gets that pausing of that 3-year statute of limitation, and that pausing can last until their 19th birthday.
Okay, now let's talk about, are there protections over or any oversight when a child is involved in this?
Right, yes. It starts, of course, at the beginning. Court has to appoint someone to prosecute the case, but it follows all the way through to the end. In a case involving a child, whether that case is settled before a lawsuit, a formal lawsuit is filed, or after it, anytime you have a case involving a child, any settlement of that case requires court approval. And of course, this is a good thing, right? I've never represented a parent that would make a bad decision for their child, but of course, these things have happened, and we want to have protections for children who really are passive players in all of this while they're children. So we have a court approval process, meaning the court has to review a proposed settlement and decide whether or not it's in the best interest of the child. Sometimes that involves appointing an outside person called a guardian ad litem who gives the court kind of an independent review of the circumstances. Sometimes it doesn't. But in the end of the day, it's the judge who decides whether or not this particular settlement is in the best interest of the child. And then the question becomes, well, what do we do with the money? What do we do with the proceeds from the settlement? Oftentimes, those proceeds are put in what's called a conservatorship. We mentioned this earlier. And that, think, is a court-supervised account that remains under court supervision until the child turns 18. Again, this is just an added protection to make sure that the money that flows from a civil case is protected for the child until the child becomes an adult. There are other ways that settlement proceeds for children can be managed, but the basic idea here, think, is court supervision from beginning to end.
Obviously a lot to take in. How do we get in contact with you and your team?
Yeah, this is an area where I really recommend, whether people aren't sure what they're going to do, ask a lot of questions, because whether it's statute of limitations or court approval, these are things that are very hard to kind of decipher on your own. Certainly not something you should do with a Google search. So feel free to call us, 616-301-3333. You can find us online. Yes, we have information on our website. We have a way for you to contact us on our website, and that's sinusdramus.com.
Okay, Tom, once again, thanks for stopping by eightWest.
Thank you for having me.
And this segment is sponsored by Sinus Dramus Law. We'll be right back with more eightWest. Don't go away.
Your all-access pass to everything West Michigan.